Right, we'll do that, yeah. But we'll have Matt, you gotta be careful. You might want to figure it out.
Senate will come to order. Please join me in a moment of silence in lieu of a devotion. Good morning.
Good morning.
Are there any announcements? By way of announcement, I would just like to alert senators, there is a printing error in your calendar. So if you look on the first page, the page numbers differ from the page numbers in the actual calendar. So you have a copied new title sheet that gives you the correct numbers. So as we go through, you'll need to refer to both pieces. With that said, we have two bills for referral under Rule 31, S56 and S135. These bills appearing on the notice calendar and carrying an appropriation or requiring an expenditure are under the rule referred to the Committee on Appropriations, and I guess that is S56 and S135. We have a Senate bill for introduction, S140, introduced by Senator Watson of Washington District and others. Please listen to the first reading of the bill.
S140, an act relating to an energy storage study committee.
Now the bill has been read the first time and is referred to the Committee on Natural Resources. We have a House bill for reference, H470, introduced by the Committee on Government Operations. Please listen to the first reading of the bill.
H470, an act relating to miscellaneous amendments to alcoholic beverage laws.
Now you've heard the first reading of the bill. It is referred to the Committee on Economic Development. That brings us to the orders of the day. We are going to briefly pass over S99 in order to get copies of amendments. We are also passing over S89, which will bring us to the third reading of S47, a series of third readings. S47, an act relating to transport of individuals requiring psychiatric care. Are there any amendments before third reading? Seeing none, please listen to the third reading of the bill.
S47, an act relating to the transport of individuals requiring psychiatric care.
Now you've heard the third reading of the bill. The question is, shall the bill pass? Are you ready for that question? If so, all those in favor signify by saying aye. Aye. All those opposed, nay. The ayes have it, and you have passed S47, an act relating to the transport of individuals requiring psychiatric care. We have on the calendar S73. Are there any amendments before third reading? Senator from Windsor.
Thank you, Mr. President. The pages are handing out the Clarkson-Sears amendment for your consideration. So I'm going to let them do that, if I may. While they're doing that, may I address a question that was raised on the floor yesterday?
You may.
To address the question of what, the reason I didn't answer it is that question is I was pretty sure we had more than one test. There are two pre-screening tests that are done on a regular basis, a blood test and an ultrasound. The blood test costs roughly $300. So those are the two tests right now that are the pre-screening tests. And then, of course, if anything is identified, there are much more substantial and much more costly tests that are that could be administered and would be. So I hope that answers the senator's question. Does everyone have the Clarkson Sears amendment? Great. This amendment does exactly what we talked about. Senator Sears raised as a concern of his yesterday, and it mirrored in some ways the reflection. It reflected some of the concerns of the committee. So the amendment will require that the Director of Fire Safety consider whether the language bar for the cancer presumption for firefighters who are over 65 or use tobacco products is still appropriate. So given the age of our current volunteer firefighters and given the number of chemicals I described yesterday, over 200 just in smoke, we know about PFAS in the equipment. We know there are just so many more elements that might cause cancer other than tobacco. The study committee is charged to look at those additional elements. Knowing about the causes and frequency of cancer that have increased significantly in the past 15 years, this will allow the director to report on whether those advances indicate that the law should change. For example, as I just had mentioned, perhaps tobacco use should only bar the presumption with certain types of cancers, and perhaps the age limit should be increased to 70. This won't be a scientific study. This will report back for us for action, but it does give the director and the study committee the opportunity to look at these additional issues. So Senator Sears and I ask for your support. The committee supported this amendment and we ask for your support.
The question now is, shall the bill be amended as recommended by Senators Sears and Clarkson? Are you ready for that question? If so, all those in favor signify by saying aye.
Aye.
All those opposed, nay. The ayes have it, and you have amended the bill as recommended by the senators previously mentioned. The question now is, shall the bill pass? Oh, please listen to the third reading of the bill.
S73, an act relating to workers' compensation coverage for firefighters with cancer.
The question now is, shall the bill pass? Are you ready for that question? If so, all those in favor signify by saying aye.
Aye.
All those opposed, nay. The ayes have it, and you have passed S73. We have on the calendar for third reading S103. Are there any amendments before third reading? Please listen to the third reading of the bill.
S103, an act relating to amending the prohibitions against discrimination.
The question now is, shall the bill pass? Are you ready for that question? If so, all those in favor signify by saying aye.
Aye.
All those opposed, nay. The ayes have it, and you have passed S103. Finally, we have S112. Are there any amendments before third reading? Please listen to the third reading of the bill.
S112, an act relating to miscellaneous subjects related to the Public Utility Commission.
The question now is, shall the bill pass? Are you ready for that question? If so, all those in favor signify by saying aye.
Aye.
All those opposed, nay. The ayes have it, and you have passed S112. I believe we're now ready to return to S99, which is on the calendar for third reading. Are there any amendments prior to third reading? Senator from Windsor.
Thank you, Mr. President. I'm rising today to
show you an amendment that I've introduced. I'm grateful to the Senate Transportation Committee who spent time to work with me to craft this amendment and their patience, as this is the first amendment that I've introduced as a brand new senator. So I greatly appreciate that patience. This amendment, which you can find on page 600 of your calendar, I believe that is correct, both listed. That was not one of the errors that need to be reprinted. My amendment looks at addressing onerous and problematic vehicle noise. This has been crafted with support of the committee and seeks to have the DMV Public Safety Commissioners and the Vermont League of Cities and Towns report on current and potential enforcement practices around excessive motor vehicle noise. It also seeks to make recommendations on ways to limit that excessive vehicle noise in our state. The objectives of the report would be to answer the valuable questions that were raised even in Senate Transportation as they considered the amendment on the cost and approaches to minimizing excessive vehicle noise, and if we should consider a standard, for example, in the periodic inspection manual, and look at the costs of all of those possibilities. I would ask that this body support the amendment because it begins a conversation in addressing what I'm sure you've all heard loud and clear from your constituents, which is excessive vehicle noise is affecting quality of life for many of our Vermonters. So I appreciate the body's time in looking at this amendment. Thank you.
Recognize the senator from Chittenden Southeast.
Speaking with the secretary prior to this, I was encouraged to stand and state that with the committee, your committee on Senate Transportation heard the senators from Windsor's amendment and supports it. So, friendly amendment.
The question now is, shall the bill be amended as recommended by the senator from Windsor, Senator White? Are you ready for that question? If so, all those in favor signify by saying aye. Aye. All those opposed, nay. The ayes have it, and you have amended the bill as recommended by the senator from Windsor. I believe we have a further amendment of S99. I'd like to recognize the senator from Addison.
Thank you, Mr. President. The pages are circulating the amendment as I speak, but as you may recall from when this bill was up, thank you, for second reading, I raised some concerns about sections 40 through 43 of the bill, which would have not withstood an entire title of state statute and any rules associated with that title for a 2-year period while the Department of Motor Vehicles did their technology upgrade for the motor vehicle system. And I raised concerns that for the precedent that this might set for state law, especially with a lot of other pending technology upgrades in other departments and agencies. So that Committee on Government Operations took some testimony from the Department of Motor Vehicles, from the Agency of Digital Services, and from our Legislative Counsel. And the Chief Counsel raised some serious constitutional concerns with the language that was in S99 and the separation of powers between the legislative branch and the executive branch, and making sure that we as the legislative branch retain the right and the authority and the ability to amend law, and that the executive branch not have the authority to do so without our full action. And even an individual committee, including the Joint Transportation Oversight Committee, does not have the authority that the full legislative body does. So after hearing about those concerns and hearing testimony from the Department of Motor Vehicles about what their needs are for this project, and from the Agency of Digital Services about what types of things might happen in the course of implementing a new technology plan, the Legislative Council attorneys worked with the department and the agency to come up with the language that you'll see in the amendment that you just received. And just a note, that whole Committee on Government Operations took testimony on this, but in order to accommodate the Transportation Committee and take up the bill today, the full committee did not have time to review this amendment together. So you'll only see 3 members of the GovOps committee on it, myself and Senator Clarkson and Vyhovsky. It does not mean that the committee is not supportive, it's just that means that we didn't have time to go over it together. But you'll see that the amendment strikes out the 4 sections that were of concern and replaces one of them with section 40. And it starts with a series of findings that essentially lay out what we heard in testimony from the Department of Motor Vehicles about what their needs are. And it's important for legislative precedent that we include these findings so it's clear why we're doing what we're doing. So you'll see that you can read them yourself, but it lays out what they're trying to do and the timeline in the time that they need to do it. It's the DMV core system modernization project, and it includes an estimated launch date in November of 2023, and then the module that is starts on February of 2024 and will take approximately 18 months to implement. And this is important because the timeline that was in the original bill was actually different. It wasn't the actual timeline for the project. It was just a blanket notwithstanding of state law. Then there's language about the design and implementation of the project, and then the services that they're trying to provide with this module, and the processes that they need to that are regulated by certain chapters of Title 23, which is the title about motor vehicles. In that title, there are many, many other chapters that have nothing to do with the work that this project would do, and they would have been not withstood under the original language in the bill. And then after it lays out all of the findings, that goes through page 1 and 2 and on to page 3, most of the, and importantly, it talks about a collaborative partnership between the department and the General Assembly, that's us, through the driver services module, monitored during legislative adjournment by the Joint Transportation Oversight Committee, the Joint Fiscal Committee, and the House and Senate Committees on Transportation, that provides the best opportunity to save money, promote transparency, streamline the process of amending statute to optimize potential efficiency for Vermonters, and serve as a model for collaboration between the branches of state government in future modernization projects. So it really lays out what we hope will be a model for other agencies and departments to use as they upgrade their technology systems. As we all know, there are many departments and agencies that are going through technology upgrades everywhere, from the Department of Children's and Family and their module related to childcare, to the Department of Labor and their entire system of unemployment insurance. So this does then create a series of reports that report back to those committees that we're at and to the full legislature about what changes to statute may be necessary, so that the committees of relevance have a heads up about what might be necessary for full legislative action during the legislative session. And it creates then joint meetings and report back through April of 2025, which is the anticipated end date to their project. And it retains our General Assembly oversight to the extent practical. The Joint Transportation Oversight Committee, Joint Fiscal Committee, and the House and Senate Committees on Transportation shall promptly express any concerns to the department regarding any department recommendations contained in any written report or testimony provided pursuant to these subsections. And then it has a separate effective date for this section, and then every other section takes effect on July 1st of 2023. Mr. President, your Senate Government Operations Committee wants to make sure that our government functions in a way that is legal and that retains our ability as the state legislative body to make the laws that we are empowered by our Constitution and the U.S. Constitution to make. And it's very important that we maintain these even in the face of technology upgrades and processes of agencies and departments. We want to make sure that the Department of Motor Vehicles is able to serve Vermonters and do it in an effective and efficient way. And we also want to make sure that they are following the statute and the rules that we as a legislative body have passed. So with that, Mr. President, I hope that this body will support this amendment. Thank you.
Thank you, Senator from Madison. For response from the Committee on Transportation, the Senator from Chittenden Southeast.
Thank you, Mr. President. Your Committee on Transportation met this morning and heard from the Senate from Madison, and we view this amendment as friendly.
Thank you, Senator. Question now is, shall the bill be amended as recommended by the Senator from Addison and others? Are you ready for that question? If so, all those in favor signify by saying aye. Aye. All those opposed, nay. The ayes have it, and you have amended the bill as recommended by the Senator from Addison. Please listen to the third reading of the bill.
S99, an act relating to miscellaneous changes to laws related to vehicles.
The question is, now, shall the bill pass? Are you ready for that question? Senator from Chittenden Southeast.
Mr. President, as the reporter of the bill, I was hoping to follow up on some questions raised during the second reading of the bill. Regarding sections 4 through 13, there was questions raised on license plate registration stickers. It was asking if it would still be a primary violation for not having a vehicle registered operating on Vermont roadways without that sticker. Primary violations will still exist for not having a vehicle registered, but not having a sticker on your plate will not be a justification for a vehicle stop. That's in 23 VSA subchapter 307A. Which states a person shall not operate a motor vehicle nor draw a trailer or semi-trailer unless all required registration certificates are carried in some easily accessible place in the motor vehicle. On that topic, we did hear, as was mentioned during discussions at the second reading, we did hear testimony from law enforcement that they have access to whether or not a vehicle is registered and can look that up by license plate number without there needing to be a sticker. So what will no longer be a violation, primary or secondary, is not displaying that sticker. But it will still be a violation to operate a vehicle without displaying license plates, which is separate from these registration stickers. Regarding section 39, questions were raised about the intent of this report. The report is in part being driven by the desire for logging trucks, which are usually carrying loads that are hard to divide. You cannot split a log as easily as splitting up grain, for example. So to be able to haul under an annual permit at weights that are consistent with those in New York and Canada was mostly the impetus for this. That is why the Commissioner of Forest, Parks and Recreations, or designee, is one of the collaborating individuals, and why the impacts on the forest economy and the management and forest cover of the Vermont's landscape are to be examined. Another question raised on this section was about the study language regarding municipal weights. This study does not explicitly require getting rid of all the municipal weight permits. However, DMV has been working towards a central portal for municipal permits since it was authorized by the General Assembly through 2020 Acts and Resolves number 149, section 26A. Regarding the now amended sections 40 and through 43, this DMV modernization project is a big deal. It's why this language allowing for flexibility was sought by the administration, and why we had a joint transportation oversight committee disapproval process, and why there was flexibility with time and purpose limitations. The administration tells me this was inspired by many factors, including the very detailed, narrow, and rigid complexities of our motor vehicle statutes relative to other state statutes. This chamber could look at just sections 4 through 13 of this bill. These 10 sections were needed to change the stickers we require on our license plates. This long overdue major modernization effort is to a core function of our state government is going to intersect a lot of our existing state statutes. That being said, this new language brought forward by the senator from Addison is a welcomed approach to achieve that end. A question was asked who is on the Joint Transportation Oversight Committee membership. Transportation, I think I also said Joint Technology Oversight Committee, the second reading, my apologies. This is on page 50, lines 15 through 17, chairs of the money committees in House and Senate Transportation. Lastly, regarding sections 44 to 46, the administration proposed to preserve the split of 90-10 in place for the last 4 years. but it's currently through temporary means. This language is effectively making permanent the 90-10 split, avoiding the reversion to an 85-15 split. So really sections 44 to 46, in my little more than 2 years in doing this, is actually stopping a sunset from happening and instead continuing it until amended. So I thought that was remarkable, ending a sunset. Thank you, Mr. President. Those are my follow-up remarks on S99.
Thank you, Senator. The question is now, shall S99 pass? Are you ready for that question? If so, all those in favor signify by saying aye. Aye. All those opposed, nay. The ayes have it, and you have passed S99. We have been asked to pass over S138, and we will do so. We have on the calendar for action S27. It was referred to the Committee on Judiciary, which reports it has considered the bill and recommends that the bill be amended as set forth in the calendar for today, and that when so amended, the bill ought to pass. The bill was then referred to the Committee on Appropriations, which reports that it has considered the bill and recommends that the bill ought to pass. Please listen to the second reading of the bill.
S27, an act relating to reducing the imposition of cash bail.
Now you've heard the second reading of the bill. I'd like to recognize the senator from Chittenden Central, Senator Vihovsky, for a report of the Committee on Judiciary.
Thank you, Mr. President. May I speak to the strike all amendment?
You may.
Thank you. Cash bail is a concept that many consider to be a simple one, and prior to taking up S27, I would have agreed. However, what we learned in committee is that this issue is not one that is well understood, and in many instances that leads to it not properly being requested or applied. The Vermont Constitution addresses bail in Chapter 2, Section 40. May I quote from the Vermont Constitution?
Without objection.
Excessive bail shall not be exacted for bailable offenses. All persons shall be bailable by sufficient sureties except as follows. 1, a person accused of an offense punishable by death or life imprisonment may be held without bail when the evidence of guilt is great. 2, a person accused of a felony, an element of which involves an act of violence against another person, may be held without bail when the evidence of guilt is great and the court finds, based upon clear and convincing evidence, that the person's release poses a substantial threat of physical violence to any person and that no condition or combination of conditions of release will reasonably prevent the physical violence. A person held without bail prior to trial under this paragraph shall be entitled to review de novo by a single justice of the Supreme Court forthwith. 3, a person awaiting sentence or sentenced pending appeal may be held without bail for any offense. A person held without bail prior to trial shall be entitled to review of that determination by a panel of 3 Supreme Court justices within 7 days after bail is denied. Except in the case of an offense punishable by death or life imprisonment, if a person is held without bail prior to trial, the trial of that person shall be commenced not more than 60 days after bail is denied. If the trial is not commenced within 60 days and the delay is not attributable to the defense, the court shall immediately schedule a bail hearing and shall set bail for that person. No person shall be imprisoned for debt. As the Constitution states, bail may be withheld under certain circumstances in order to protect the community from violence. However, the Vermont courts have ruled that cash bail may not be used in order to protect the community from a defendant or to hold someone that is believed to be dangerous. This does not mean that this person must be released, but that using bail to hold this person would be a misuse of the bail system and unconstitutional. In an instance when the defendant is deemed to be a risk and when no conditions of release can mitigate that risk and the evidence against them is strong, the court may choose to hold that individual without bail. There have been multiple cases in Vermont that have stated that bail may only be used to ensure that a defendant returns for their court hearing, and further, the Constitution states that bail should be set at a rate that is reasonable to be paid by the defendant. And yet, on January 13th of this year, the Department of Corrections reported that nearly 200 people were being held pre-trial simply because they had not posted bail. This bill does nothing to stop allowing the state to hold dangerous defendants without bail. This bill only seeks to address bailable offenses. There is a significant and growing body of evidence that cash bail not only is not the most effective tool to ensure a defendant's appearance in court, but it is also disparately and inequitably applied and holds people in jails before they have had the due process guaranteed to them simply because they are poor and cannot afford to post their bail. This is in direct opposition to the values of equity and fairness, and is in fact in opposition to the Vermont Constitution, which states clearly, no person shall be imprisoned for a debt. So what does this bill do? It will eliminate the use of cash bail for non-listed misdemeanor offenses beginning in 2025. We heard that this will in fact impact few Vermonters, given that at this time, few Vermonters with this category of charge are being held on bail in our DOC facilities. This bill also tasks the Sentencing Commission to bring a report to us in December. The Sentencing Commission is comprised of the following individuals: the Chief Justice of the Vermont Supreme Court, the Chief Superior Court Judge, a Superior Court Judge with substantial criminal law experience appointed by the Chief Superior Judge, the Chair of the Senate Committee on Judiciary, the Chair of the House Committee on Judiciary, the Attorney General, the Defender General, the Executive Director of the Department of State's Attorneys and Sheriffs, the Appellate Defender, a State's Attorney appointed by the Executive Director of the Department of State's Attorneys and Sheriffs, a staff public defender with experience in juvenile defense matters appointed by the Defender General, an attorney with substantial criminal law experience appointed by the Vermont Bar Association, the Commissioner of Corrections, the Commissioner of Public Safety, the Executive Director of the Vermont Center for Crime Victim Services, the Executive Director of the Vermont Crime Research Group, and one member of the public appointed by the Governor. The Commission is tasked to collaborate with the following community partners: the Vermont Network Against Domestic and Sexual Violence, the Community Justice Unit of the Office of the Attorney General, Vermont Legal Aid, the Vermont Office of Racial Equity, the Vermont Chapter of the American Civil Liberties Union, the Vermont Freedom Fund, and national experts on bail reform. A report is due to the committees of jurisdiction on December 1st, 2023, on what conditions are needed in order to end the use of cash bail as the means to ensure that a defendant returns for their court hearing. A system that has been shown not to be the most effective and is doing harm to Vermonters. A system that we can replace with a better system under the right circumstances. This is not a new idea. Other states and jurisdictions in the nation have eliminated cash bail or greatly limited its allowable use. New York, New Jersey, New Mexico, Illinois, Alaska, Atlanta City, Harris County, Texas, Jackson, Mississippi, Washington, D.C., and even our federal criminal courts have all recognized that there are more effective and more just means of ensuring that people show up to court. In many of these jurisdictions, the rate of appearance in court with pretrial supports and a robust notification system are in fact higher than the rates of appearance in court than when they relied on a cash bail system. The federal criminal courts eliminated the use of cash bail in 1984. Instead of releasing someone based on their cash on hand, the federal courts hold a hearing to determine if the person charged poses any danger to the community or is likely not to come back to court. If so, the court then determines whether there are non-financial conditions of release, like reporting to a supervision officer, drug testing, or other conditions that can address those concerns. We heard testimony that even a couple of days spent incarcerated increases the rates of recidivism, has negative impacts on employment, housing, and families, and has a detrimental impact on the outcome of these cases. For the 200 people held because they cannot pay bail, harm is being done to them, their families, and all of our communities. This bill also tasks the judiciary with implementing a pre-trial notification system to reduce the rate of failure to appear by July 1st of 2025. They too are to provide a report on December 1st of 2023 to the General Assembly about how they will do this and what they will need to implement it. These reports are due to the committees of jurisdiction ahead of the 2024 session so that we may take action ahead of the reduction in cash bail aspect of this bill going into effect in 2025, which will allow us to consider the findings of the reports and whether or not we need to make changes to the 2025 implementation. The committee took testimony from Jessica Barquist, the Director of Policy and Organizing at the Vermont Network Against Domestic and Sexual Violence, Michelle Childs, Legislative Counsel at the Office of Legislative Counsel, Erin Jacobson, the Co-Director of the Community Justice Division at the Attorney General's Office, Al Johnson Kurtz, a member of the steering committee for the Vermont Freedom Fund, which is a grassroots organization that provides bail to Vermonters who cannot afford it. And they testified that they're nowhere near meeting the need. Jennifer Pullman, the executive director for the Center for Crime Victim Services, Indy Schoenherr, the policy advocate with the ACLU of Vermont, Rory Tybalt, an attorney with the Vermont Department of State's Attorneys and Sheriffs, Matt Valerio, the Defender General at the Defender General's Office, Judge Thomas Zone, the Chief Superior Court Judge with the Vermont Judiciary. We also received written testimony from Miriam Krinsky with the Fair and Just Prosecution Network and Aaron George from the Bail Project. The committee voted 4-1-0, and we ask for the body's support. Thank you.
Thank you, Senator from Chittenden Central. I'd like to recognize the Senator from Lamoille, Senator Westman, for a report from the Committee on Appropriations.
Mr. President, I think this bill went in the category in appropriations where the questions around the table, why did this come to our committee? As we heard from the reporter from Judiciary on this impacts very few Vermonters. There is in section 1, number 2, a section where it states the court may impose bail in a maximum amount of $200, and that is, they strike in this bill. So we found, I think it's fair to say, a very de minimis effect on any of the state revenues, and we supported the bill 700.
Thank you, Senator. The question now is, shall the bill be amended as recommended by the Committee on Judiciary? Are you ready for that question? Senator from Windsor.
Thank you. May I inquire of the reporter of the bill?
Senator from Chittenden Central will be interrogated.
Thank you. I applaud this effort in large measure, although I am concerned about the capacity of our Department of Corrections to actually do the additional supervision. You said that this has been successful on the federal level, and on other levels, if we do more drug testing and if we have really terrific supervision. And I am just wanting assurance from the committee that they felt that the capacity of the department was there on both those counts.
Thank you for the question. This is part of why we've tasked the Sentencing Commission to really go through, and the Department of Corrections does sit on the Sentencing Commission, and have asked them to report back to us what they would need to implement the adequate supports and supervision.
Great, thank you very much.
Thank you. Again, the question is, shall the bill be amended as recommended by the Committee on Judiciary? Are you ready for that question? If so, all those in favor signify by saying aye. Aye. All those opposed, nay. Nay. The ayes appear to have it. The ayes do have it, and you have amended the bill as recommended by the Committee on Judiciary. The question now is, shall the bill be read the third time? Are you ready for that question? If so, all those in favor signify by saying aye. Aye. All those opposed, nay. No. The ayes appear to have it. The ayes do have it, and you have recommended third reading of S27. That completes the orders of the day. Recognize the senator from Chittenden Southeast.
Thank you, Mr. President. I move that the rules be suspended and H411, an act relating to extended COVID-19 healthcare regulatory flexibility appearing on the calendar for notice, be taken up for immediate consideration.
Senator from Chittenden Southeast has moved that your rules be suspended and that we take up for immediate action H411, an act relating to extending COVID-19 healthcare regulatory flexibility. Are you ready for that question? If so, all those in favor signify by saying aye. Aye. All those opposed, nay. The ayes have it, and you have suspended your rules, taking up for immediate action And I would recognize the senator from Chittenden Southeast for a report from the Committee on Health and Welfare.
Thank you, Mr. President. And thank.
Excuse me, Senator. Please listen to the second reading of the bill.
H411, an act relating to extending COVID-19 healthcare regulatory flexibility.
And now, the Senator from Chittenden Southeast.
Thank you, Mr. President. And I do want to thank the Senate for allowing this bill to go forward. It is time sensitive, requiring the signature by the governor by March 31st. So we are a bit of a time crunch, but I think we'll be fine. The bill that you have before you is the bill that was passed to us from the House, and the Committee on Health and Welfare has made no changes to the bill. So it is, there's no amendment that I'm presenting, simply the bill that we reviewed in our committee. You know, we all think that we're past COVID, but the reality is that it's ongoing. In 2021, there were 26 patients in the hospital at this time. In 2022, there were 53 patients in the hospital. And in 2023, there are 42 patients with COVID in the hospital. So we're still working on caring for patients and finding resources to cure this disease. This bill is deja vu all over again for those of you who have been in the Senate for a while. And for those of you who are new, it is, this bill represents some flexibilities that we have given to various agencies, departments, licensing organizations to increase the access to workforce during the COVID emergency. And the original bill goes back a bit. So if you look at the top of the bill, you'll see various acts from 2020 and 2021 and 2022. So we have gone through and extended the flexibilities that you see before you. There are some that are missing. So we've eliminated some as we have coped with the realities of COVID. When we had folks come in, I want to share with you first, some of the folks who came in to talk with us were our long-term care folks, Vermont Medical Society, the hospitals, and others who have worked together outside of the legislature to look at the effectiveness of the work that we've put into our legislation in terms of the flexibilities in the bill. And they came back very enthusiastic, indicating that how important some of the licensure pieces and some of the regulatory flexibilities have been to increase workforce and to care for people, to provide vaccinations, to provide treatment, and so on. So what we did in the past couple of years has been important to our really outstanding work in the state in caring for people and preventing the spread of COVID overall. And then the request, of course, that's in this bill is to continue the sections of the bill will continue through until March 31st, 2024. There'll be some slightly different dates at different places. But the importance that we're seeing here is for telehealth, for licensure of physicians and other professionals, nurses and others, and some of the work that goes on in our pharmacies, staffing for long-term care, responding to a new seasonal virus that COVID may become our new seasonal virus. So all of the things that are included in this bill are things that are seen as important to respond to the ongoing needs within the state in response to the COVID epidemic. So I will go very briefly through the bill, and I'm happy to answer questions, but I know where we are in our lives in terms of time in this Senate. But if you look at sections, and just as an FYI, the sections in the bill you'll see section 12, which is under section 1 of the bill. And Section 12 is an extraction, a current statute from a previously passed flexibility bill. So please don't be confused by the section numbers. I'm going to go through section 1, 2, 3, 4, and 5 of the bill, and I will be referring to what's in those sections, not by the section numbers that you have. But if you find something you'd like to talk about or ask a question about, just let me know, and I'm glad to look at where you're referring. So sections 1 through 3 of the bill extend certain parts of various acts that we looked at previously. So it grants authority for the Secretary of Human Services to waive certain rules or standards governing providers of health care and within the human services, gives the Green Mountain Care Board some flexibility in how they deal with budgets or other rate setting or other rules that they are responsible for. It authorizes the Department of Financial Regulation to adopt emergency rules for health insurance covers for diagnosis, treatment, and testing of prevention of COVID, provides flexibility for provider credentialing from Medicare and Medicaid and other health insurers. These have been all very useful in the past and should be useful going forward. One of the things that I would note is that the bill offers an opportunity for buprenorphine prescription renewals to continue without an office visit. And this is something that we will probably be looking at to make more permanent going forward because the experience has been very helpful to folks around the state. Another part of sections 1 through 3 are the ability for out-of-state licensed healthcare professionals to provide services in Vermont as volunteer members of the Medical Reserve Corps. And this is for up to 6 months. So if you're licensed out of state, you can come in and practice for up to 6 months if you register in with the Board of Medical Practice and others. So this has been extremely helpful. It also would limit certain professions under the Office of Professional Regulation. There's a new section in the bill. This is the only new thing that's come to us that's in the bill that's different from all of the previous acts. And that is if someone has been deemed to have an appropriate license for practice in the state, they're from out of state, and they've been deemed appropriate to practice in the state, then that licensure would be deemed appropriate for hospitals and other settings in the state, not simply so that they wouldn't have to go through another process for determining their capacity to practice. Another section is waiving the HIPAA-compliant connection requirements for telemedicine to the extent that's permitted under federal law. Telemedicine has been absolutely essential in our past several years. Gives authority to the Board of Medical Practice to issue temporary licenses to out-of-state providers and waive certain requirements for physician assistants. And the next one is a sunset on a sunset. So this is similar to what we heard from the reporter from Senate Transportation, that we are eliminating the sunset on the pharmacist's authority to order and administer COVID tests. So going forward, pharmacists will continue to be able to order and administer COVID tests. There's no sunset on that. So that is one place in the bill where we have learned from our experience and will put in place something permanent. Section 4 of the bill is a temporary telehealth registration for out-of-state healthcare professionals. So this section removes the June 2023 end date from existing temporary telehealth registration and allows for the out-of-state professionals to continue with telehealth licensure and practice. It also in Section 4 requires the Office of Professional Regulation and Board of Medical Practice to provide appropriate notice to healthcare professionals registered under the temporary telehealth registration option of the expiration date of the option and allow them 90 days after the applicable rules take effect to transfer from temporary registration to their regular telehealth license or registration. And if you recall, which you may not, but we were putting in place, OPR is putting in place in collaboration with the Board of Medical Practice, a out-of-state registration process for telehealth in the state. And so there will be, this just adds into the process to help folks get that permanent licensure and registration or registration for telehealth in Vermont. Section 5 deals with our advanced directive law and allows for remote witnesses and explainers. I won't go into all the detail on the advanced directive program, but there are witnesses who need to sign off when you give your advanced directive, and then there are explainers who help you understand, should you need that, what is in your advanced directive and what's going on. So this extends the remote witnesses and remote explainers until next year, March 31st. And then Section 6, Board of Medical Practice report on licensure, looking to streamline and modernize physician licensure. This is a new section that came to us from the House, and it's an important one to make it offer some facility for medical practitioners to become licensed in the state of Vermont. The bill is effective on passage because there are so many deadlines in here that are March 31st or no later than April 1st, 2023. It's really important, and I thank you for considering the bill and hope you will vote favorably.
Thank you, Senator. The question is, shall the bill be read the third time? Are you ready for that question? If so, all those in favor signify by saying aye. Aye. All those opposed, nay. The ayes have it, and you have ordered third reading of H411. Senator from Chittenden Southeast.
Mr. President, I move the rules be suspended and H411, an act relating to extended COVID-19 healthcare regulatory flexibility, be placed in all remaining stages of passage.
Senator from Chittenden Southeast has moved that your rules be suspended and H411, an act relating to extending COVID-19 healthcare regulatory flexibility, be placed in all remaining stages of passage. Are you ready for that question? If so, all those in favor signify by saying aye. Aye. Those opposed, nay. The ayes have it, and you have suspended your rules in order to take H411 through all remaining stages of passage. We have H411. Are there any amendments before third reading? Seeing none, please listen to the third reading of the bill.
H411, an act relating to extending COVID-19 healthcare regulatory flexibility.
The question now is, shall H411 pass? Are you ready for that question? If so, all those in favor signify by saying aye. Aye. Those opposed, nay. The ayes have it, and you have passed H411. Senator from Chittenden Southeast.
Thank you, Mr. President. I move the rules be suspended and H411, an act relating to extended COVID-19 healthcare regulatory flexibility, be messaged to the House forthwith.
Senator from Chittenden Southeast has moved that the rules be suspended and H411 be messaged to the House forthwith. Are you ready for that question? If so, all those in favor signify by saying aye. Aye. All those opposed, nay. The ayes have it, and you have suspended your rules and messaged H411, an act relating to extending COVID-19 healthcare regulatory flexibility, to the House forthwith. At this point, I would recognize a motion from the Senator from Windsor.
Thank you, Mr. President. Pending announcements, I would move that the Senate be adjourned until Friday, March 24th at 11:30 a.m.
Senator from Windsor has moved that pending announcements, the Senate stand in adjournment until 11:30 a.m. Friday, March 24th. Are there any announcements? Senator from Addison.
Thank you, Mr. President. Senate Natural Resources and Energy will meet tomorrow morning at 8:30.
Senator from Washington.
Thank you, Mr. President. Senate Finance will meet at 1 o'clock.
Senator from Bennington.
Thank you, Mr. President. Senate Education will meet at 1:45.
Senator from Addison.
Thank you, Mr. President. Senate Government Operations will meet at 1:30.
Senator from Essex.
Thank you, Mr. President. Senate institutions will meet today at 1 o'clock.
Any further announcements? Senator from Chittenden Southeast.
Thank you, Mr. President. May we take a tiny recess so I may consult with the secretary?
I will declare an extremely brief recess. Other announcement. Seeing none, the senator from Windsor has moved that the Senate stand in adjournment until 11:30 a.m. Friday, March 24th. Are you ready for that question? If so, all those in favor signify by saying aye. Aye. All those opposed, nay. The ayes have it, and we stand in adjournment until Friday at 11:30 a.m.